Hello, welcome to this virtual training. My name is Doris Cotto. I am a senior educator at the Center for the Development of Ethic Thought of the Office of Government Ethics of Puerto Rico. I will be offering the training about the Code of Ethics for the public servants and former public servants of the Government of Puerto Rico. The main purpose of the Puerto Rico Government Ethics Act of 2012 as amended and known as the Organic Law of the Office of Government Ethics of Puerto Rico is to renew and reassert the preventive and overseeing duties of the office. The policy of prevention incorporates values into public service to make feasible the attainment of the highest levels of honesty, integrity, and efficiency in the performance of public servants. The body of laws established by this statute seeks to formulate a code of ethics that regulates the behavior of active and former public servants of the executive branch of the Commonwealth of Puerto Rico government. It is constituted as a guiding principle of this legislation to prohibit inappropriate actions that endanger the stability of the moral integrity of the state. The office oversees, through the mechanisms and resources available, to penalize all those who infringe the ethical standard of the Commonwealth of Puerto Rico government. The law entered into force on January 3, 2012, and I will refer to it as Act 1, 2012. Let's take a look to the objectives of the training. At the end of the training, public servants made understand the ethical prohibitions included in the Government Code of Ethics, apply the ethical standard to the exercise of their official management in government agencies, integrate ethics as a job discipline in their daily execution. Let's know who the statute applies to. The Code of Ethics applies to the executive branch of the Government of Puerto Rico. The executive branch is composed of the agencies under the central government, public corporations, boards, municipalities and their municipal legislatures, special corporations for municipal development, local areas for job development. Who is a public servant? A person in the government who may or may not be involved in the drafting and implementation of public policy and carries out his or her duties permanently or temporarily, whether for pay or not. Also includes freelance contractor whose contract equals a job position or office, or whose responsibilities include being directly involved in the drafting and implementation of public policy. Let's examine the general ethical prohibitions. The transgression of many of the articles of law we are going to examine in this section constitute felonies. Our office is not empowered to impose criminal sanctions. The commission of a felony under Act 1, 2012 is referred to the Justice Department of Puerto Rico, specifically to the Public Integrity Division, and the criminal sanctions will be applied after the celebration of a trial by a judge of the First Instance Court of the Commonwealth of Puerto Rico. Let's know about the prohibition related with benefit requests for an agency. No public servant shall solicit any benefit for his or her agency, whether directly or indirectly, from a private person, business, or public entity regulated or contracted by the former, or carry out actions conducive to obtaining a contract. A public servant may only accept a benefit for his or her agency from a private person, business, or a public entity that is neither regulated nor contracted by the former, or that does not carry out actions leading to obtaining a contract provided that he or she complies with the regulations adopted for such purposes. Benefit is any avail, utility, profit, or gain without limiting the term to a pecuniary or material gain. Also includes any form of advantage. The concept is not limited to an economic gain, but includes any form of advantage. The benefit has to be for a program, project, or activity that has a public purpose. Let's talk about the use of property, public funds, and the duties of office. No public servant shall exploit the duties and powers of his or her office or public property or funds to directly or indirectly obtain any benefit not permitted by law for himself or herself or a private person or business. The rule is not to take advantage of the duties and powers of public office, property, and funds for personal or other benefit without a public purpose and without the authority of law. Official action cannot advance personal interests, whether economic, partisan, or other outside the public service, for itself or in favor of third parties. This constitutional principle emerged from Section 9, Article 6 of the Commonwealth of Puerto Rico Constitution. Our office prosecuted a public servant who worked as a freelance contractor for the Equestrian Sports Industry Administration from 1987 to 2013. He used an official computer to access adult pornographic content websites. He was charged with violation of Article 4.2 subsections B and S of Act 1 2012 as amended and fined with $5,000. I will continue talking about solicitude or acceptance of benefits while performing official duties. No public servant shall accept or solicit from a private person or business, whether directly or indirectly, a benefit as a compensation for carrying out, expediting, delaying, or not discharging the duties and responsibilities of his or her office. No public servant shall accept or solicit from a private person or business, whether directly or indirectly, benefits for himself or herself or a person, business, or entity in exchange for carrying out actions that are based to favor him or her or another private person or business. No public servant shall ensure that he or she may or purport to have influence over another public servant in carrying out his or her functions in exchange for obtaining or attempting to obtain a benefit. Let's talk about the use of confidential information. No public servant shall reveal or use confidential information or documents obtained as a result of his or her employment to obtain directly or indirectly any benefit to himself or herself or any other private person or business. Confidential information refers to that which is defined as confidential by the law, that which is protected under any of the privilege of evidence law, that which, if disclosed, could harm the fundamental rights of third parties or the right to privacy and the private life of public servants, the disclosure of which could constitute a violation of executive privilege when the document or information is part of a deliberation process when drafting public policy and, if disclosed, may endanger the life or bodily integrity of a public servant or another person, the security of the island, or may impair any business, transactions, or official efforts of the state in progress during when requesting such information. The term includes reports, memoranda, or any written document drafted by a public servant in discharging the duties of his or her office or job for his or her superior or in connection with internal decisions and actions of the department. Let's know what constitutes a conflict of interest and the prohibition that the code establishes. The code defines conflict of interest as a situation in which personal or financial interests are or could be reasonably inconsistent with public interest. Conflict of interest is a situation in which an individual's judgment about a primary interest to him or her and the integrity of his or her actions tends to be unduly influenced by a secondary interest, which is often of an economic or personal nature. That is, a person incurs in a conflict of interest when instead of complying ethically, he could guide his decision or act for the benefit of himself or a third party. Let's clarify the meaning of some concepts I will refer to in the succeeding subsections. Family unit are those whose financial affairs are under the control of a public servant. Control is the authority to manage the assets, liabilities, revenues, and expenditures of a person. Relative refers to the grandparents, parents, children, grandchildren, uncles, aunts, siblings, nephews, nieces, first cousins, spouse, father-in-law, mother-in-law, brother-in-law, and sister-in-law of a public servant, as well as the children and grandchildren of his or her spouse. Let's examine the prohibition against conflict of interest. No public servant shall intervene either directly or indirectly in any matter in which he or she has a conflict of interest that may result in his or her benefit. No public servant shall intervene directly or indirectly in any matter in which any member of his or her family unit, relative, partner, or housemate has a conflict of interest that may result in benefit for any of the above mentioned. In the case that any of the above-mentioned relationships has ended during the 2 years preceding the appointment of the public servant, he or she shall not intervene either directly or indirectly in any matter related to them until 2 years have elapsed after his or her appointment. This prohibition shall remain in effect insofar the benefit ties with the public servant exist. Once the benefit ties end, the public servant shall not intervene either directly or indirectly in such matter until 2 years have elapsed. Issue refers to a matter that involves specific parties in which a public servant participates personally and substantially and that requires his or her decision, approval, recommendation, or investigation. This term does not include the intervention or participation of a public servant in the promulgation of norms or regulations of general application or of abstract directives and instructions that do not pertain to a particular situation or cases. Any public servant who must take any official action that is contrary to the prohibitions established by sections 4.2, 4.3, and 4.4 should report it to the office before taking such action. Public servants always has a duty to report to the Office of Government Ethics any conflict of interest or situation which represents a possible infraction to Act 1, 2012. Our office has an inhibition mechanism available for them on the electronic portal www.eticapr.com. The public servant has to report the situation to the Executive Director of the Office of Government Ethics before intervening. In his or her statement, the public servant may request to be relieved of intervening in the matter or participating in the agency's deliberations related to the official action. The public servant should deliver a copy of the statement filed with the office to the appointing authority of his or her agency. It should always be used when an authorization is granted in the following cases: appointment and recruitment of relatives, contracting with public servants of the agency, members of the family unit, relatives, partners, or persons who share their residence, contracting with former public servants of the agency before the 2 years of the retirement. Once the situation has been assessed, the Executive Director of the Office of Government Ethics shall notify the public servant and the appointing authority that there are no conflict of interest, or should there be, that the option to disqualify himself or herself is available. The Code attends any action that affects the impartiality and integrity of the government services. No public servant shall carry out any action that may call the impartiality and integrity of the government endeavor into question. We will examine the rules relating to the appointment, promotion, compensation, or contracting of a relative in the public service. Neither the appointing authority nor the public servant with influence on the appointing authority should intervene either directly or indirectly in the appointment, promotion, compensation, or contracting of his or her relative. It should be understood that a public servant has the power to decide or exert influence when a law, regulation, description of duties, or designation so provides. This prohibition shall not apply when in the discretion of the Executive Director of the Office of Government Ethics there are special circumstances that have been taken into account before the appointing authority or the public servant with influence exercise his or her power. The appointing authority or the public servant with influence should restitute from his or her own funds any income earned and profit obtained from such office or contract as a result of non-compliance with this rule. This rule has some exceptions. Let's see. The prohibition shall not apply to a career position when the merit principle is met. Advancements or personal related transactions required by law, general revisions of a classification plan, Section 8 benefits received, public bids in which all the requirements set forth in this act concur, participation in summer programs, the obtainment of services, loan, sureties, or incentives granted under the terms of a state, federal, or municipal program. But there is a duty to report the Office of Government Ethics and activate the inhibition mechanism, request to be relieved from intervening in the matter or participating in the agency's deliberations related to the official matter. provided that under the above-mentioned exceptions, general applicable rules are complied with, and the appointing authority or the public servant with authority to decide or exert influence does not intervene and so certifies through a formal disqualification statement. Let's talk about the use of political emblems while doing the duties of job. Which ones are considered political emblems under Law 1 2012? Any symbol, slogan, image, picture, pin, logo, sticker, label, sign, insignia, technological application, written message, any other paraphernalia. No public servant shall use on any real or personal property of the government any political emblem that may identify or promote directly or indirectly the electoral interests of any political party or candidate. Personal property are those that can be transported from one place to another. Real property are those that cannot move by themselves or be moved from one place to another. To understand the following subsections related with the use of political emblems in government agencies, let's clarify the meaning of the following concepts. Electoral interest refers to the platform, agenda, ideal, formulas, or tendencies of a political party or candidate. Political party is a group, entity, or organization governed by the Puerto Rico electoral law as amended or any succeeding law. Candidate is any person who publicly announces his or her intention to seek an elected public office or who, without being the candidate of a political party, publicly announces his or her intent to seek an office or who appears on the ballot for any election. No public servant shall, while carrying out the duties of his or her office, wear or use on his or her person, in his or her property, or in any other property under his or her care, a political emblem that may identify or promote directly or indirectly the electoral interests of any political party or candidate. We will examine now the prohibition related to participation in political activities during the working day. Political activity is an event in which one or more persons promote in favor of or against a certain candidacy, political party, or issue to be considered by the voters. No public servant shall, while carrying out the duties of his or her office, lead or promote activities that directly or indirectly promote the electoral interests of any political party or candidate. Our office prosecuted a mayor of a municipality who convoked the public servants in positions of trust to a meeting in his political campaign committee. He imposed on them and demanded a monthly fee. The money would be used to defray the mayor's campaign expenses. Subsequently, he held two meetings in the conference room of the mayor's office to demand the payment of the imposed fee and participation in political activities. No public servant shall, while carrying out the duties of his or her office, make monetary contributions or use his or her time to carry out or participate in a political activity. Our office prosecuted a school director who left his place of work to fill out dozens of political recusals in an election precinct. The defendant stayed under oath before the state Elections Commission that he had made multiple efforts during his working hours, even though, according to the department's attendance record, he was registered as present throughout the day at the center. The defendant used his working hours to carry out political partisan efforts which were not related to government management. No public servant shall, while carrying out the duties of his or her office, demand or request other public servants to make monetary contributions or devote their time to carry out or participate in a political activity. Our office prosecuted a director of medical emergencies in a municipality during working hours, and in the facilities of the municipality. He encouraged and actively participated in the imposition to the personnel under his supervision of the purchase of tickets for political partisan activities, and required the employees to contribute financially for the re-election campaign of the mayor. He required, through numerous calls and text messages, the contributions to the employees under his supervision. In addition, he required them to deposit the money in the same mailbox designated for the delivery of medical content reports. No public servant shall solicit or accept by himself or herself or through a private person or business any benefit from a contractor or an agency regulated by his or her agency for a political activity. The Code of Ethics in Chapter 4 of Act 1, 2012 as amended had integrated some sections from the Criminal Code of Puerto Rico, which is Title 4 of Act 146, 2012 as amended, which constitute not only administrative transgression but also criminal. These felonies emanating from the Criminal Code of Puerto Rico are classified as felonies against the governmental function. The first felony is usurpation of office or task. No public servant shall usurp an office or task to which he or she has not been appointed or designated, nor discharge the same without being duly qualified to do so. No public servant shall persist in obstinately discharging the duties of his or her office or task entrusted to him or her once his or her term has concluded or after having received an official communication ordering the termination or suspension of his or her duties. Our office prosecuted the accounting assistant of the Department of Finance of a municipality. Since 1993, she used a forged high school diploma to obtain and move up to positions in the municipality for which she was not qualified. Our office also prosecuted a high school director who usurped the position of director of an educational region. He declared as surplus several educators of the Department of Education without having been declared as such or having received an official communication. The defendant's job description did not include that function, nor was he authorized to make that decision. No public servant shall alter, destroy, mutilate, remove, or conceal in whole or in part public property under his or her custody. No public servant authorized by law to issue certifications and other documents shall knowingly issue a certification or document containing false statements. No public servant shall fail to comply with any of his or her duties as provided by law or regulations if such action shall result in the loss of public funds or cause damages to public property. Although it emanates from the Criminal Code under Act 1 2012, the failure to comply duties does not constitute a felony. Under the Criminal Code, if the value of the loss of public funds or damage to public property exceeds $10,000, imprisonment for 3 years will be imposed. The court may impose a penalty of restitution. Our office prosecuted a public servant who worked at the Driver Services Center who, using her operator number, registered as paid transactions of imposition of administrative fines in the David Plus system of the Department of Transportation and Public Works for the quantity of $6,420. Let's examine the sections related with other jobs after completing the regular working day. No public servant shall fail to comply with any of his or her duties as provided by law or regulations if such action shall result in the loss of public funds or cause damages to public property. Although it emanates from the Criminal Code under Act 1 2012, the failure to comply duties does not constitute a felony. Under the Criminal Code, if the value of the loss of public funds or damage to public property exceeds $10,000, imprisonment for 3 years will be imposed. The court may impose a penalty of restitution. Our office prosecuted a public servant who worked at the driver's. No public servant shall accept or keep a job or contractual or business relations or responsibilities in addition to those of his or her public office or employment, whether it is in government or in the private sector, which, although legally permitted, may have the effect of impairing his or her freedom of judgment in the performance of his or her official functions. No public servant shall accept or keep a job or contractual relations from which he or she obtains undue advantage with a private person or business that is regulated by or has contractual business or financial relations with the government agency for which he or she works when the public servant is empowered to decide or influence the official actions of the agency with regard to such private person or business. We will examine the content of the standard related to the approval and execution of contracts in the public service. No public servant who is authorized to contract or approve or recommend the execution of a contract in the name of the agency for which he or she works shall intervene or participate in the execution of a contract with a private person or business in which he or she or any member of his or her family unit, relative, partner, or housemate has or has had, directly or indirectly, a monetary interest during the last 2 years before his or her appointment. In the event that any of the above-mentioned relationships has finished during the 2 years preceding the appointment of a public servant, the latter shall not intervene or participate in the execution of a contract until 2 years have elapsed since his or her appointment. This prohibition shall continue in effect while the ties of benefit with the public servant still exist. Once the ties of benefit end, the public servant should not intervene or participate in the above-mentioned contract until 2 years have elapsed. The appointing authority should not execute a contract in which a public servant of the agency or member of his or her family unit, relative, partner, or housemate has or has had direct or indirect monetary interest during the last 2 years preceding his or her appointment. This prohibition shall not apply when in the discretion of the Executive Director of the Office of Government Ethics there are exceptional circumstances that have been taken into account before the appointing authority contracts with a public servant or a member of his or her family unit, relative, partner, or housemate. This rule has some exceptions. Let's see. This shall not apply to the receipt of benefits under the Section 8 program, contracts executed with the Department of Treasury to operate electronic lottery terminals, contracts executed for the acquisition of rights over intellectual property, such as literary, artistic works or inventions, public bids in which all the requirements set forth by law concur. Participation in summer programs, the obtainment of services, loan, sureties, or incentives granted under the terms of a state, federal, or municipal program, provided that under the above-mentioned exceptions, general applicable rules regarding eligibility should be observed. No public servant shall approve or authorize a contract with a private person or business, knowing that such person or business is representing cases or matters which involve a conflict of interest between the contracted agency and the personal interests said private person or business is representing. Section 4.3, subsection E, provides that to such effects, a contractual clause should be included in which such private person or business certifies that it is not involved in a conflict of interest. We will examine the rules related to private practice of a profession or trade. No public servant shall represent any private person or business, either directly or indirectly, with respect to an official action, if he or she, a member of his or her family unit, relative, partner, or housemate, has participated, shall participate, or will probably participate in the disposition of said official matter. The rule provides that the prohibition shall not apply when the participation of the public servant is required by law. No public servant shall represent any private person or business before an agency with regard to any official action in which the appointing authority is his or her relative, member of his or her family unit, partner, or housemate. No public servant shall, in his or her private capacity, represent or counsel, either directly or indirectly, a private person or business before any agency in cases or matters involving a conflict of interest of public policy between the government and the interests of such a private person or business. No full-time public servant shall during working hours represent, advise, or serve as an expert for a private person or business in trials, public hearings, or in any other case or matter before a court of justice, quasi-judicial body, or an agency. Our office prosecuted a defendant who was serving as special assistant in the office of the secretary of a department. During his working hours, he offered services as an attorney in the private practice of his profession, collecting his salary and using his regular vacation leave without being authorized by the appointing authority. Let's take a look through the rules which apply when we become former public servants. How do you become a former public servant? By transfer, resignation, inability, dismissal, retirement. No former public servant shall provide information, intervene, cooperate, advise in any way, or represent in any capacity, either directly or indirectly, a private person, business, or public entity in official actions or matters in which he or she intervene while working as a public servant. Official action refers to an action related to the functions and duties of a public servant or within the scope of the authority delegated to the agency, such as rendering advisory services, conducting investigations, filing charges, auditing, adjudicating, and rulemaking on specific areas. It also includes any process related to orders, authorizations, exemptions, resolutions, contracts, granting of permits, franchises, accreditations, privilege, and licenses. No former public servant shall, during the 2 years following the date of termination of his or her employment with the government, provide information, intervene, cooperate, advise in any way, or represent, directly or indirectly, a private person, business, or public entity before the agency for which he or she works. No former public servant shall, during the year following the date of termination of his or her employment with the government, hold an office, have monetary interest or contract, directly or indirectly, with an agency, private person, or business over which he or she has taken an official action during the year preceding the termination of his or her employment. Intergovernmental contracts shall be excluded from this prohibition. This prohibition shall not apply to former public servants who wish to return to the specialized non-government sector for which he or she served, provided that his or her official actions have not favored the entity where he or she intends to hold office, in which he or she has a monetary interest, or with which he or she contracts. In order for this exception to be valid, the executive director of the Office of Government Ethics should evaluate the situation before the former public servant takes office, holds monetary interest, or executes the contract. Amendment to Act 1, 2012 under the Act 135/2013 states that the municipal governments are excluded, so they may hire in a part-time job former public servants of their municipality, conditioned on the fact that they have ceased their functions to benefit from retirement due to age of years of service. The appointing authority shall not enter into a professional service contract with or for the benefit of a former public servant of his or her agency until 2 years have elapsed since the date of termination of his or her employment with the agency. This prohibition should not apply to ad honorem professional service contracts. It should neither apply when, in the discretion of the Executive Director of the Office of Government Ethics, there are special circumstances that have been evaluated before executing such contract. If there are special circumstances and the Executive Director of the Office of Government Ethics authorizes the contracting of a former public servant within 2 years following the date of termination of his or her employment, the professional service contract should not establish compensation higher than that earned for carrying out the same duties when he or she was a public servant. Amendment to Act 1 2012 under the Act 135/2013 states that municipal governments are excluded and may hire former public servants from their respective municipalities at any time, conditioned that it is a part-time job and that they have ceased their functions to benefit from retirement due to age or years of service. No former public servant may use confidential or privileged information obtained while discharging the duties of his or her office for his or her own enrichment or the enrichment of a third party. It should be understood that there has been enrichment not only when wealth has increased with money or property, but also when the liabilities affecting the person have been cancelled or extinguished. Let's know about the sanctions that Executive Director of the Office of Government Ethics should impose to public servants and former public servants who infringe the ethical standard. Any person who infringes the prohibitions and provisions established in Chapter 4 and in the regulations, orders, and norms promulgated thereunder may be sanctioned by the Executive Director of the Office of Government Ethics by an administrative penalty fee which will not exceed $20,000 for each transgression. The foregoing shall not limit the power of the Executive Director to impose a treble damages sanction in addition to said administrative penalty fee. The Executive Director may impose for transgressions of any of the provisions of this chapter when applicable the following administrative measures: to declare null any contract executed or appointment made in contravention of the provisions of subsection H of section 4.2 and subsection D of section 4.6. Whenever a contract or appointment is declared null, the appointing authority concerned should restitute from its own funds any income earned and profit obtained from such office or contract. To order restitution, to order the agency concerned to make deductions from the payroll of a public servant at fault until the administrative penalty fee imposed is paid as provided in section 2.3 subsection Q of Act 1 2012 as amended. To consider recidivism when imposing an administrative penalty fee or the sanctions provided in section 4.7 subsection D of the referred act. The code includes a judicial action for non-compliance with administrative or civil sanctions. Any person who fails to comply with a final and binding administrative penalty fee or sanction and or with any final and binding civil sanction, the Court of Justice may impose 10% interest at the prevailing legal rate, whichever is higher, on the amount owed, as well as the payment of attorney's fees in favor of the government. The interest should begin to accrue from the time the sanction becomes final and binding. Any violations of the provisions of this chapter may be punished as applicable by any of the following actions imposed by the appointing authority: written reprimand, summary job suspension, suspension from job and pay, removal or discharge. Under the criminal sanctions, the offenses set forth in Chapter 4 shall not prescribe. Convicted persons should be disqualified to hold any public office or employment. The person who is interested in returning to public service after serving his sentence in a prison institution must comply with the process established in Act Number 8, 2017, known as the Act for the Administration and Transformation of Human Resources in the Government of Puerto Rico, to rehabilitate himself as a public servant. Under the civil sanctions, the office shall be empowered to request the San Juan part of the Court of First Instance to issue an injunction to prevent any violation of this chapter and file the proper actions to recover the civil sanctions imposed on behalf of the state. Request that the execution of any official action which constitutes a violation of the prohibitions established by this chapter be barred, suspended, or stayed. Any person who receives financial gain as a result of a violation of this chapter shall be bound to pay the state as a civil sanction for noncompliance a quantity equal to 3 times the value of the financial gain received. As a reference, I used the Puerto Rico Government Ethics Act Number 1 of 2012 as amended. Thank you for taking the training. I trust the information shared will help you in the exercise of your official duties. For answers to questions about the content, you can contact the Legal Advice and Litigation Area of the Office of Government Ethics or by email at consultas@oeg.pr.gov.